Good morning, all. Thank you for attending and a Happy New Year to all of you. This is the 26th meeting of the Joint Select Committee on Finance and Legal Affairs. And this is our first public hearing into the inquiry into the feasibility of widening the availability of non-custodial penalties in the criminal justice system. Members of the public who are listening on the radio or looking on television may send comments or questions during the course of this session via Parliament's various social media platforms. This morning, the committee welcomes the Director of Public Prosecutions and representatives from his office, representatives from the Trinidad and Tobago Police Service, representatives from the Trinidad and Tobago Prison Service, and representatives from the Ministry of National Security. Now, starting from my left, I will ask everyone to introduce himself to the committee, please.
Pleasant morning. I am Carlos Caraspi, the Acting Assistant Commissioner with responsibility for offender management.
Pleasant morning to the committee. I am Gerard Wilson, Commissioner of Prisons, Acting.
Good morning, Madam Chairman and members of the committee. Vel Lewis, Permanent Secretary of the Ministry of National Security.
Good morning. My name is Roger Gaspard. I'm the Director of Public Prosecutions.
Good morning. My name is Trisha Hudlin Cooper, Assistant Director of Public Prosecutions.
Good morning, Chairman and members of the committee. My name is Nigel Pilgrim. I'm a State Counsel 3 at the Office of the Director of Public Prosecutions.
Good morning. My name is Devda Dulalchan. I'm an Acting Deputy Commissioner of Police.
Good morning. I am Joanne Archie, Acting Assistant Commissioner of Police Operations.
Good morning. I am Jason Ford, an Acting Assistant Commissioner of Police.
Good morning. I am Sintra Maharaj, Chief Probation Officer.
Good morning. I am Marian Taylor, Probation Officer 3, Acting.
Good morning. I am H. Walker, Chief Prison Welfare Officer.
Good morning. I am Randolph Orozco, Assistant Superintendent of Prisons, Acting.
Thank you all. Now I will invite members of our committee to introduce themselves. Dr. Henry.
Morning, everyone. Lester Henry, member of the committee.
Morning all. Taharko Bika, member.
Good morning, Clarence Rambrad, Vice Chairman.
And good morning all. Vidya Gaidin Gopi Singh, member.
And I'm the chairman of this committee, of the Joint Select Committee, and my name is Sophia Choot. Now, before we begin, just so that we can focus our attention on why we are here, I'm going to read out very quickly the 3 objectives of this inquiry. The first is to assess the efficacy of non-custodial penalties in dealing with the backlog of criminal cases. 2, to determine whether non-custodial penalties may ameliorate high recidivism rates. And 3, to ascertain what are the critical requirements or prerequisites for the wider application of non-custodial sanctions in the administration of justice. Now, there is a protocol that we normally follow when we hold these inquiries, and that involves the head of each attending group making a brief statement for 2 minutes on the proposed objectives of the inquiry or with respect to their position or how they see things. So I will ask the Director of Public Prosecutions, Mr. Roger Gaspard, SC, to open, and if you can give us a brief opening statement of 2 minutes, we will be very grateful.
Thank you very much, Madam Chairperson. Before I embark on my opening statement, may I hasten to apologize for the late submission of our response to the committee's inquiries. I would indicate at this juncture that that late submission was not as a result of anything disrespectful or any indication to be disrespectful, but rather because of the exigencies and the pressures of work. Be that as it may, Madam Chairperson, the topic at hand this morning is both apposite and timely, having regard to the fact that it must be that institutionally and systemically we may be doing some things quite wrong. Having regard to the burgeoning, if not galloping, crime situation in Trinidad and Tobago today, this topic assumes especially sharp relief, since it cannot be gainsaid that the mere warehousing, to use a term that is rather popular these days, of prisoners is not the panacea for dealing with the galloping crime situation, both in terms of the national community's goals and in terms of those little issues touching upon recidivism and reoffending. It is my respectful view that this particular topic and its treatment and the discussion today is overdue, and I expect and pledge on behalf of the DPP's office to do all in our power to further the discussions this morning and to meet all inquiries with the fullest response. Thank you very much.
Thank you, Mr. Gaspard. And we accept your apology, but please be advised that it seems as though everybody was late. You were not unique in that regard. But we do appreciate the fact that everyone made an attempt to send us something in writing prior to today's meeting. May I now invite Mr. Lewis to make an opening statement of about 2 minutes.
Thank you, Madam Chairman, and again, good morning to you and the members of the committee. Like the DPP, I also would want to apologize for the late submission of our document to you for much of the same reasons. And again, we would want to assure you that no disrespect was meant in that delayed submission. We would also want to thank the committee for the opportunity to appear here this morning, and with me, the Commissioner of Prisons and the Chief Probation Officer, along with members of their teams. We want to welcome this discussion, this inquiry. We want to welcome the initiative of non-custodial penalties. This could certainly have some positive impacts for us in terms of the possible reduction of the prison population and, of course, the attendant negativities that come out of that. We see this as well as an opportunity for widened scope of work of the probation services. And in fact, the Ministry of National Security has actually begun to develop that particular division to recruit additional members of staff and the likes in preparation of an outcome such as this. So again, I want to give the assurance that this is something that the Ministry of National Security would embrace, and we would want to continue supporting the work of this committee. Again, we are happy to be part of these inquiries this morning, and we give you the assurance of our continued support. Thank you very much.
Thank you, sir. May I invite the Acting Commissioner of Prisons, Mr. Wilson, to make an opening statement.
Morning, Madam Chair and members of the committee. I'd just like to take this opportunity to wish you and the other members a bright and prosperous 2019, and also to all viewers and listeners. Madam Chair, the prison service continues to be committed to the criminal justice system. We continue to look at reformation and rehabilitation as one of our watchwords. And our concern would be that we continue to get the particular resources and add value to what we do. I am extremely pleased that we have been invited here this morning. I think that it's a conversation that we need to have. And now that we have met, and yesterday I spoke with members of the probation department, and in other jurisdictions there's this nexus between the prisons and the probation. And I hope coming out of this, we'll be able to have a closer association that would benefit our clients, as we call them now. So that for the prison service, we are on board, and we hope that coming out of this meeting and these deliberations, we'll be able to get have that impetus to continue to make a change. And of course, our goal in the prison is public safety. So I thank you.
Thank you, Commissioner. May I invite comments from Acting Deputy Commissioner of Operations, Mr. Dulalchan?
Madam Chair, appreciate the opportunity. The Trinidad and Tobago Police Service recognizes that sentencing is about more than just punishment of offenders. Non-custodial penalties have the ability to place controls on the behavior of offenders who do not have to be held incarcerated in prison and warehoused, as it was previously alluded to. Non-custodial penalties have the potential to rehabilitate offenders and to restore justice to victims when coupled with specific programs geared towards these goals. Therefore, the TTPS supports the implementation of non-custodial penalties coupled with strict supervision and programs geared towards social integration, rehabilitation, and restorative justice, which can have positive outcomes once monitored and managed properly. I thank you.
Thank you, Deputy Commissioner. Now, the way we are going to structure our hearing this morning is a bit different from how we've done it before. I think because we recognize the fact that the Director of Public Prosecutions has had to attend before various parliamentary committees over the last few months, and we know how valuable the time of the Director and his staff is. What we will focus on first, Director, if you don't mind, is we will deal with our questions for you, and then if you wish, we will allow you to be relieved to return to your offices.
Madam Chairperson, rest assured that I have set aside this time to provide any assistance my office can this morning and into this afternoon if necessary, so that there's no need for me to be relieved. I am very much interested in hearing what the other stakeholders have to say in relation to this very, very valuable topic.
Excellent. So I just want to remind everyone that questions are asked through the chair, and you also answer through the chair. When you speak, please ensure that your microphone is put on. I suppose there is nothing at this point then preventing the inquiry, the actual inquiry beginning. So does any member want to begin? Sure.
To the police service, I just wanted to know, open with the question, what role do police prosecutors play in recommending non-custodial sentences?
With respect to each offense that, or each trial before the learned judge or magistrate, there is, in fact, enshrined in statute what is the minimum or maximum sentence. I know for a fact that there is, in fact, mitigating factors that plays a role, but I don't think, and subject to correction, that they on the outset will indicate that a non-custodial sentence should be a consideration for determination or pronouncement by the magistrate or the judicial officer.
Is there a program of training for police prosecutors?
Yeah, we do have training. Training is ongoing, and we also source that training externally from members of the judiciary as well as officers from the office of the DPP.
And does this program of training include the views of the Trinidad and Tobago Police Service on the possible efficacy of non-custodial sentences?
I don't think so.
I just want to inquire, Acting Commissioner, you represent operations. Does operations include your court and process division?
No, it doesn't, ma'am.
Do you have a representative here from the court and process division?
Mr. Ford, who is the ACP crime, court and process branch falls under his remit.
So perhaps, Mr. Ford, you may be able to assist us. Do we have any statistics from the court and process department with respect to offenses prosecuted by the police in which non-custodial penalties were imposed?
Madam Chairperson, good morning to you and the panel. Now, statistics in the Trinidad and Tobago Police Service is gathered by our crime and problem analysis branch. And I believe as we sit here, we should have statistics. Unfortunately, I do not have those statistics with me as we speak, but if need be, I can make all attempts to get them and share them with you, please.
Excellent. The committee is always willing to receive material, whether written or oral, after the hearing if you have material which you think may assist us in our deliberations. But we are certainly interested in what statistics the court and process branch may have collected over recent years with respect to cases in which non-custodial penalties have been imposed.
Madam Chair, I am guided, and that information will be forwarded to you.
Thank you.
Thank you, Madam Chair. The question I have is for the police service. What role does the community policing arm of the police service play in assisting the decision to go into, for offenders in particular, non-custodial sentencing? Please, sorry, the microphone here.
At this point in time, I have data where 25 persons were sent to the community policing section. 25 by magistrates and 1 person by a judge, I think. And they came there as a form of, for rehabilitation. And after they would have gone through the various processes and so on, feedback went back to the judge and in cases the magistrates, and where they would have determined sentencing. In fact, I was told that one of the persons who was in that program is now a member of the Hugh Woodin Law School.
Morning again. My question is for the DPP. In your submission, you mentioned that litigants were generally not using the petty civil court to handle their disputes involving sums of less than $50,000. I would like to know some more about this, why you think that is the case, and what could be done to improve that situation, if that would be one of the solutions to this problem. Yeah, it's on page 2 of your submission, from your.
It is difficult to say why litigants are not availing themselves of this particular facility. This lies more in the civil arena, which falls outside my immediate remit. But what I do know is that because of this, you find that the magistrates' courts tend to be overburdened. And sometimes a magistrate may be better placed. There's an opportunity cost to a magistrate sometimes sitting in the petty civil court as opposed to a court dealing with criminal matters. So that may exacerbate the problems as they pertain to resources and timeliness and disposal of matters in the magistrate's court as those matters pertain to the criminal law arena.
So would you recommend some kind of program to improve the use of the petty civil court? So could that be one of our takeaways here today? Because I was personally unaware of the lack of use of this court until I read it in your document. Right? Could we see that as a possible avenue to explore to help, as you say, decrease the burden on the magistrates who deal with criminal matters and so on?
It can be, but there would be a need for the thinking of individuals, almost a slight shift in the thinking of individuals so that they may be persuaded to do otherwise.
Okay, so a public awareness campaign or something like that? So.
Yes, and sometimes the urgings might properly come from the magistrate in question, or the presiding magistrate. Everything, I mean, yes, we are becoming more and more litigious, but to a large extent, persons can be encouraged to deviate from the litigation route, sometimes by way of moral suasion, and sometimes by a healthy administration of common sense.
Through you, Madam Chair, to the DPP, you have said in one of your response, and even in your opening statement a while ago, that there are systemic and institutional shortcomings. And you also said having non-custodial remit is not really the panacea. What are these systemic and institutional shortcomings that you think you need to fill that gap and to see how we can move forward in bringing some changes to the criminal justice system?
Without purporting to give you an exhaustive list, when I speak about systemic and institutional shortcomings, I am focusing or placing the accent on resources. There's a crying need for an increase perhaps in the number of judicial officers, the number of magistrates, the number of probation officers. There may be a need as well for probation officers to see their roles as being perhaps more holistic as opposed to episodic or limited to the extent of their merely furnishing a report pursuant to a court order. You find in other jurisdictions where focus is placed on this particular accent, the role of the probation officer tends to be much wider than the role usually embraced, from my experience, by probation officers in this jurisdiction. If we are to cultivate healthy diversion streams, for instance, the creation, say, of community courts, again, you have the issue of building space, you have the issue of personnel, you have the issue of resources, you have the issue of, at the prisons, you would find that, unlike in the case of convicted prisoners, many of the prisoners are on remand, and I'm not too sure what type of treatment, what type of intervention the prison service makes in relation to remand prisoners, bearing in mind, of course, that remand prisoners enjoy the presumption of innocence, and they would have been found guilty by no court. When you look at the prison statistics, and the goodly prison commissioner would be better versed to speak on these, it appears to me as though remand prisoners constitute a fairly large segment of the prison population. So when I spoke about institutional and systemic changes, the action really is on resources.
Well, perhaps I could pose a question at this stage before I come back to a couple of other issues raised. I could pose a question to the Chief Probation Officer. Can you give us the disparity between what you actually have in terms of numbers in your department as opposed to how many officers you would require?
Okay, Madam Chairperson, as it is right now, we have 35 probation officers on the establishment, 2 being the chief and the assistant chief probation officer, who are more in terms of administration. We have 5 probation officers, 3, those positions are filled. We have 16 probation officers, 1s, and 12 probation officers, 2s. Now, that is just a meager amount based on the amount of duties that we have to fulfill. So I could understand how the DPP, I know we do a lot of reports, and a lot of our focus really is to try to churn out reports for the magistrates, high court, appeal court. And that puts a strain on the limited capacity we have in terms of the amount of probation officers to do the report, the actual supervision. However, we have gotten an increase in terms from to address both 2 situations. One will be the children's court, where we would have gotten 18, we would have gotten 3 children probation officers, 3, 6 probation officers, children probation officer 2, and 18 children probation officer 3. Now, this is going to be on the establishment. So prior to having these people on the establishment, which will take probably between 2 to 3 years, we have gotten approval for 2 children probation officer 3s, 4 probation officers 2, and 18 probation officer 1s. Now, one of the problems is...
I'm sorry to interrupt, but before I lose my train of thought, would these officers who are filling positions within your department, would these officers be confined in their duties to the children's court?
The ones that, the children's court will definitely be confined to the children's court. But, the children's probation officers, but we have also gotten cabinet approval to hire a number of other probation officers, but that process is going on with Service Commission, and there was some internal. Okay. What we have is, as we speak, shortlisting has been completed, and we are in the process. I understand from Service Commission that it should happen within the financial year, I'm hoping, all things being equal. Now, the numbers in terms we were guided by PMCD in terms of the numbers, and based on our statistics that we would have had from before, and the numbers that came up would have been what we would have gotten. We had to, they would have cut some that we think we would have needed, but new, we will be having some new duties coming up in terms of possibly electronic monitoring and that kind of thing. So I guess we'll be able to look at it after 3 years, 1 year, sorry, to determine whether or not we will be needing more probation officers.
Well, how many do you need currently?
Definitely over, probably over 50, because probation officers are attached to each magisterial district. And so in some areas, we're going to need more than the stipulated amount. So a definite figure is very difficult to come up with at this point in time, but it all depends on the amount of work that we have to do, not only for the court, but then we have other duties too, which
sure.
Court. Yeah.
I see the PS trying to catch my attention. So do you have something you wish to add to this?
Yeah, I just wanted to add that the additional staff that the positions that were created for the probation division was actually done based on an assessment of the staffing requirements at the time. And therefore, those positions were created based on that assessment. What I'm hearing with the DPP is that he seems to suggest that we need to have an expanded role for the officers. And it is something that we have perhaps hitherto not considered. And it is certainly something that we would want to sit down and look at in a serious way in terms of the role, the duties and responsibilities of the probation officer.
That's an excellent point, because if I may just say, one of the roles that probation officers now have to take on is the role of witness before the court. So that expanded role of learning how to testify and that kind of thing is becoming more important. So, Permanent Secretary, has there been consideration by your ministry for training of officers, further training of officers along these lines?
Certainly, there is a training plan, so officers are at various intervals exposed to training. But with respect to the expanded role and what the DPP talked about that obtains in other jurisdictions, is something certainly that I've taken note of here this morning, and something that I would want to sit with the Chief Probation Officer and the other personnel of the ministry to look at and to determine how we could see an expansion in the role of the officers.
Thank you.
Thank you, Chair. I've looked at the submissions from the DPP and I've looked at all, but in particular the police service and the DPP. And I think particularly from the police service, I think there is a more fundamental problem, which is that we've not actually researched and we do not have access to data on the performance of non-custodial sentences. That is clear. We have some guidance from other jurisdictions. We have some academic learning, but there is no local research and no data that we could rely on in terms of the performance of non-custodial sentences. That is clear to me. And maybe all of you could indicate what recommendations can come out of this inquiry which will allow you to really assess the value of non-custodial sentences. So that's my first point. The second thing is that I've listened to the issue of resources and the other factors. It it is very clear that non-custodial sentencing fits into a number of other issues in the criminal justice system, and this committee has already conducted an inquiry into the criminal case management system, where we heard and we reported on the issues of staffing at the DPP, staffing elsewhere, buildings and other issues relating to the criminal justice system. So I personally like to be careful that we do not go back into an examination of the wider criminal justice system, but that we focus on the efficacy of non-custodial sentences within the criminal justice system. The third point I would make is that there may be a link between non-custodial sentencing and the backlog. That has to do with the way we approach the prosecution of cases and the opportunities for non-custodial sentencing upfront. But I think my interest is in the other aspects of it, how a non-custodial sentence impacts on the person on whom it is imposed, the likelihood of re-offending. I think the DPP's views on that are very clear, where you've highlighted two things. One is that it may not necessarily avoid repeat offenders, one. And two, you've made a very important point, DPP, in saying that when somebody who has been convicted comes back up for sentencing on a second offense, non-custodial sentencing in the current arrangements may not be available. Those are my points. Yeah, anyone? Maybe the DPP can respond.
Thank you very much. The question that you would have posed is a very valid question. If we are speaking or looking into the feasibility of widening the availability of non-custodial penalties in the criminal justice system, we must adhere to data. And as far as I know, the data in this regard is rather slender. So it causes us to be hamstrung to some extent in assessing the issue of feasibility. So as far as I'm concerned, you are quite correct. In relation to the impact of non-custodial sentences, I heard the member focus on the impact on the offender. And I would just like to indicate that, in my view, for any criminal justice system to achieve its just deserts, while the interests of the offender are critical, the interests of the victims are just as critical. And if we are to assess the feasibility of widening the availability of non-custodial penalties in the criminal justice system, some focus must be placed also on victim impact statements, especially in the context of restorative justice principles.
Deputy Commissioner Dulalchan, I raise the issue because your written submission points to both the absence of data and the absence of local research, and through no fault of the Trinidad and Tobago Police Service. But do you see the need for that work to be done, and is it possible that the police service will try to allocate resources for that to be done?
I think really for us to really make the kind of informed presentation here, the research is critical. And I have no doubt that is something that we see value in as a TTPS. There will, in fact, be cost-benefit analysis. And I can give a commitment here. We do, in fact, have a research department, and I think it's something that we can probably task them to.
And just as a follow-up to the DPP's submission, could you tell us a little bit about the victim impact statement and the role that it plays in prosecution?
Yeah, well, I think it's important really to, I mean, the victim here, we need to satisfy the victim. At the end of the day, there is need for victim satisfaction here. And I know for a fact that with respect to the sentencing, there is confrontation. There's where you find that face-to-face, the offender may show remorse, may apologize. There are instances where compensation, depending on what offense was perpetrated. But I think key here, whilst we understand that non-custodial sentence can probably release some of the stresses within the systems in the criminal justice system. I mean, we must take into account the message we want to send to society as a whole and the victim himself or herself.
Officer Dulaljan, I want to return to something which you had said earlier, which is to say, when asked about whether your officers who are prosecuting in the courts ever recommend non-custodial sentences, your answer was no. May I ask why?
Madam Chair, that's the information. That's the information that I was able to discern before coming here.
What is the source of your information? May I inquire?
I attempted to get some information through one of the officers who was detailed to do this research in presenting our written comments to you.
Well, perhaps I should pose my next question to Officer Ford. Is there a policy decision that police prosecutors will not recommend non-custodial penalties in certain cases or in all cases?
Madam Chair, the process as it relates to the presentation of evidence. Madam Chair, the process as it relates to the presentation of evidence in our courts is that we have two sides, and the prosecutor will present the state's case. Upon completion, the law basically gives the magistrate the leeway to determine how to impose sentencing. The knowledge that I have is that traditionally the prosecutors do not enter into that realm and give an account as to whether it should be custodial or non-custodial.
Perhaps I should say that used to be the case. Now prosecutors are entitled to address the court when it comes to sentencing, and in fact, the Judicial Education Institute has produced its second edition on guidelines with respect to sentencing. So prosecutors certainly have the option in the appropriate case to recommend non-custodial penalties. I find it somewhat odd that this change in the legal position, having existed for some time, does not seem to have trickled down the police prosecutors. But be that as it may, Honorable DPP, may I ask this question of you? Now, on a previous occasion, when you had appeared before this committee, we had spoken very briefly about the efficiency of the Plea Bargaining Act. And what I wanted to inquire is whether there is more use of the Act, and if so, whether the kinds of cases which are considered under the Act attract or appropriate for non-custodial penalties.
Madam Chairperson, there appears to be some cultural reason why greater use isn't made of plea bargaining. Usually, you would find that plea bargaining, where it is usually used in relation to High Court matters. That may be something to be looked into, and it may have arisen as a result of a certain level of cultural stasis. But there's nothing debarring you from embarking on a plea bargain, whether under the Act or informally. Because before the Plea Bargaining Act, for all practical purposes, there would have been bargaining between the state and defense counsel, or between the state and a defendant or an accused person, sometimes even at the invitation of a presiding magistrate. But you would find that in this jurisdiction, there appears to be a reluctance to embark on plea bargaining.
Why is that? I mean, is it that because the ones that have been engaged in are not acceptable to the person offering to plead guilty, or is it just that people don't know that they can use this mechanism?
I think people can always be better informed. I think people can always be better informed, and I also think that there needs to be a greater consciousness of it in the sphere of the defense counsel or the private bar. Because as it stands, everyone seems to want to have his day in court regardless. So greater use can be made of plea bargaining. And as I reiterate, whether formally under the Act or informally.
That's an excellent suggestion. I know I was just about to invite you, Commissioner Wilson, but I know that you want to have an input into this.
Madam Chair, thanks for the opportunity. I wanted to make 2 points. One is, of course, non-custodial, this non-custodial process will impact positively on the prisons because of overcrowding. That's one thing. When someone comes into the prison system, we're looking at overcrowding, and it's not a secret to anyone. We also look at contamination. There, that mixing with because of the overcrowding and the fact that we can't really, carry through the process as we should. There's contamination. And I think that in a case like that, mediation may help even before the matter goes to court. And I think that mediation was quite popular not too long ago. A lot of lawyers were even, doing that particular program. But the DPP raised an issue of restorative justice, and this is where I wanted to comment, because it has become a buzzword, restorative justice. And I start to say, even amongst my staff, they may not quite understand what is restorative justice. Sometimes they mix it up with minimum standard rules. So that if you hand an inmate a glass of water, they say it's restorative justice. If you say thank you to them, it's restorative justice. But the minimum standard rule says that the only thing that a person loses while they're incarcerated is their freedom. So even listening to the radio, looking at television is not something that you take from them, okay? It's surprising to most people, but that's a fact. What I'd like to say based on this whole restorative process, I'd like to give it, with your permission, ma'am, a scenario. Someone is held for probably a stick of marijuana, or someone is held for breaking in a school and stealing computers. So he steals 2 computers from a school. So he's sentenced and he probably gets a year or 2 years. And he's more or less warehoused. What good does that do to us and the general public? So I'm thinking, probably the school may need 2 or 3 classrooms painted. This particular person is also a good painter. So 2 things you do. He broke into the school because he has a drug habit. So 2 things you do. You give him the opportunity to seek help for his drug habit. So you're dealing with his drug problem. He paints the school, which would have saved that school about $30,000 because they were about to embark on, raising funds to paint the school. So he paints the school. By doing that, he saves them $30,000. So they are able now to buy 10 computers. So the victim that the DPP spoke about wins in the process because the victims would be the teachers and the children. So from 3 computers being stolen or 2, they now have 10, based on the fact that this person has a skill. So we send them for help, counseling, and he also uses his skill to help save the school some funds. In my view, that's real restorative justice taking place there because we take cognizance of the fact that victims are involved. I just want to point out, too, that some years ago, I remember 2 young children were exposed to a particular crime. I would not call names, but if you could recall, I know that you recall, ma'am, that one of them, the female, went on to do well, while the male ended up incarcerated, and he was a victim. At that point, they were children, and they suffered the consequences as victims because nobody took the time to think about the victim. We always think about punishing the offender, but looking at the victim is crucial to us in this whole criminal justice scenario. So I just wanted to make those 2 points. Thanks.
Thank you, Senator.
So thanks, Chair. Basically, I wanted to ask a follow-up question for all 3 in front of us, the prisons, police, and DPP. It's regard to the perception that soft penalties, notwithstanding the beauty in the revelation of your answer, the soft penalties and its connection to perceived increases in vigilante justice in Trinidad and Tobago. How do we reconcile that challenge if we are to be introducing an increased number of non-custodial sentencing, but preventing vigilante justice by the perceived victims?
I think mediation in this particular scenario will be crucial because we have to study, if we're looking at a soft sentence, as you may deem it, sir, and whether there would be some retaliation from the persons so offended. I think mediation is crucial, and if we can have that, introduced in the whole process, it may curb any sort of vigilante approach to that particular scenario. This is how I view it.
I want to solicit a response from the DPP as well as the police service, but with respect to, in general, and in respect to child maintenance. So where persons are sentenced based on maintenance arrears or non-payment, how do we reconcile that? Because we know that the Single Fathers Association is getting prominence, and that is a separate topic, but it's connected to this issue. How do you reconcile the victim and the victim being satisfied at the same time restoring the offender? For either DPP and the police service, given your role.
Well, first of all, the characterization of a particular initiative as a soft penalty is something that I may take light exception to. In my view, based on the discussions that we are having, it mightn't be so much about a soft penalty as an appropriate penalty in the context of what is currently facing Trinidad and Tobago in terms of the warehousing of prisoners who perhaps ought not to be warehoused, especially for lengthy periods. So I'm not sure if the premise is correct in terms of the characterization or categorization of the penalties as soft. The second point I would wish to make is that I do not know that one can easily identify a causal connection between vigilante justice and what you may have referred to as a soft penalty. So I do not know that soft penalties lead to vigilante justice or they do not lead to vigilante justice. This might be something, again, which should be made the subject of some research and some empiricism, since while we are speaking about it as a fact, it may not be a fact, and there may be no real link between soft penalties and vigilante justice. But not only that, even if there is a link, if we are analyzing this thing comprehensively, then you would have to look at that in the context of a situation where victims of crime find that the system takes too long to administer justice to them or for them, so that too may lead to vigilante justice, and that too should be made the subject of some research. Because of the length of time before a victim of crime has his day in court, that undermines public confidence in the judicial system, and as a result of that, persons might feel more inclined to take the law into their own hands. With respect to the issue of maintenance, I'm not too sure I understood exactly what your question was in relation to that particular issue.
Allow me to explain. If an individual, a parent, is imprisoned, incarcerated for maintenance, for non-payment of child support, as we call it in Trinidad and Tobago, it may be perceived to be defeatist because really and truly, if they're in prison, they can't support their children in the first place. So given that, how do you reconcile non-custodial sentencing with respect to non-payment of child support?
If I may intervene at this point, perhaps the director is not the person to proffer a point of view on this because it really doesn't fall within his remit, but perhaps we can hear from one of the representatives of the TTPS on this matter.
Madam Chair, I just want to indicate that non-custodial sentencing does not mean that an offender does not have to be sentenced. That is to say that offenders have been fined. Offenders have been placed on a bond. And in some cases, offenders are in fact reprimanded. And we're talking about punishment here, but a different type of punishment as opposed to custodial punishment. When someone is fined, the money goes into the consolidated fund. Now, with respect to one not paying the maintenance, I cannot see how fine there can in any way assist. Because in the first instance, the reason why you've been arrested or a warrant was issued for you is that you did not have the money to pay whatever monies you have to pay for the maintenance of your child or your children, as the case may be, right? I don't know to what extent it really helps, because obviously the person being incarcerated doesn't mean to say that he's working in prison to see if he can probably pay whilst in prison whatever fine. And that's...
Thank you, Mr. Dulalchan. But I think this spins straight into your court, Commissioner. because one of the things we would want to find out is how many people do you have incarcerated for non-payment of maintenance currently?
All right, I'll let the offender management, Mr. Karaspi, he will have the statistics to give you, ma'am.
Yes, thank you, Madam Chair. From our statistics that was provided, the breach of maintenance order this time, we have 47 persons so circumstanced.
47?
47 persons.
I see. I think what the member was trying to inquire about, Mr. Dulalchan, is, Commissioner Dulalchan, is about other options, not necessarily a fine, other options such as community service and so on, as opposed to imprisonment for non-payment of maintenance monies. What is your view on that, Commissioner of Prisons?
Madam Chair, that's a good point, because some of these persons incarcerated for this particular issue will tell you, if I'm incarcerated, I'm not working, how can I pay? And then what happens too is that at the expiration of that particular period, when they come out, they are rearrested for, of course, for arrest. So that creates a scenario for them. I have spoken to a few of them who there's a level of hatred after a while, because some of them even say, I'm not going to pay it, I'll just make the time and continue to do that. So that we have to look at probably a more creative way of getting, because at the end of it, Madam Chair, the children suffer. So that we have to look at probably a creative way to get around that, yeah.
Acting Deputy Commissioner, Mr. Dulalchan, I would imagine that the TTPS has to devote a certain amount of its resources, personnel and so on, to have these warrants executed on persons who have not paid child maintenance and that kind of thing. Do you have any data to say how many members of your staff or of the TTPS are on a weekly basis or monthly basis engaged in having these kinds of warrants executed and having these persons brought before the court?
Madam Chair, I know that is a daily activity. It happens in our 77+ station districts. It will be difficult for me now to really quantify the amount of officers, but I know it is a tremendous amount of resource. But just to suggest, I don't know much about arrangements with employer and employee, but whether considerations can be given where these persons who are in fact in the employ, whether there can be some arrangement where even before the offender receives his salary, whether or not whatever pronouncement has been made respect to that respective matter at the magistrate's court, whether something can be done at that point in time, I can't say. But I think that that is something that can be considered, where the person is forced to. He's forced to make his contribution, because at the end of the day, the bigger picture really is the maintenance and the care and comfort of the children.
Thank you. Mr. Wilson, I'm using your minimum standard rules, and I'm using a submission here. And I'm seeing 964 inmates are due to be released within the next 24 months, meaning that they are there in excess of 3 years. We have 180 inmates sentences are forfeitable by payment of fines, 19 forfeitable by payment of compensation, 1 by payment of debt and cost, and 19 sentences are forfeitable by payment of maintenance arrears. So we have 964 persons there warehoused, using your words, And it's a cost to keep these persons here. And we are looking at the type of, the commission of offense. Don't you think that perhaps these are some of the offenses that could gain some maybe leeway in using non-custodial penalties?
Through the chair, definitely. I totally agree with you. I have had discussions with Mr. Karaspi, who is in charge of offender management. And we have looked at those issues. So when we receive this information in terms of non-custodial, we felt that those are some of the cases that can be looked at, similar to the recent events where those who would have pleaded guilty by the courts would have been allowed to just complete their sentences. So that is an interesting point, and it's something that we can all look at, and that's why I'm happy that we have the police service, probation, and prison. And I hope that after this, we can all sit and have the same conversation, and of course, come up with recommendations that would suit the process.
Also, I've been hearing words like restorative justice. We are hearing word of rehabilitation and so. But is it that any of the groups, the police, the prisons, and even with networking perhaps with the Ministry of Education, that we do something which is prophylactic, is preventative? Has there been any sort of networking with these different institutions, in particular to look at the Ministry of Education, where you would have perhaps the principal, you might get a list from the students submitting to the principal and identifying students who may be disruptive students and the potential of those who may have some mental issues. And perhaps if you could have maybe some programs to deal with that at the onset, we will not have all these problems here. That with the overcrowding and the rehabilitation, it's costing money to do all these different, which we call setting up committees and to do these different programs. So the question is, are there any programs that you may want to start to have or to initiate where you can network with the Ministry of Education to start to pick out those students who may be prone and become vulnerable for the commission of offenses later?
Okay, well, through the chair, ma'am, sometimes at the youth training center, schools would visit to more or less bring a shock to those students who may be a bit deviant at times, so that I don't know how much that helps. But I want to say at this point that I know that the police youth club, is doing a pretty good job by trying to keep the youths in line. We also have the prison we also introduced the prison youth club. And through the youth clubs, we have tried to introduce programs to prevent them from entering into even the youth training center. So that I know that we have collaborated, the prison sports club and police sports club, we have collaborated a bit in getting some program to keep the youths in line. So that's the only thing I can tell you about at this time.
And I don't want to leave out Mrs. Joanne Archie, but the commission of offenses by females, how prevalent is it, like with respect to the young females?
Well, whilst it is not as prevalent as the males, we still have, I would say, a moderate percentage of women committing, young women, and we are seeing more and more young women, and I'm speaking about between the ages of 15 to 25 committing offenses. How we treat with that? Through, again, our community policing units and the youth clubs, which falls under the community policing unit. And I want to agree with Mr. Karaspi, who suggested that the programs that we should have and should be in place to assist in that regard, and you alluded to it, I think we should have a closer collaboration with the agencies involved as a proactive measure. I think it's not as strong as we could have it. And for instance, aligning with NGOs in the community. In this case, I know Commissioner Wilson, and Mr. Karaspi, also myself, we are on the board of the Vision and Mission, who are doing an excellent work as it relates to reintegration. And if we can work closer together, I think we can come up with more vibrant programs that we will see reduction in even the recidivism in the communities.
Thank you very much. And this is directed to PS and Commissioner Wilson. One of the views on non-custodial sentencing is that it would lead to a reduction in the costs at the prisons. When I looked at the submission, using a prison population of 3,933, what I saw, when I think about the prison, for example, I thought that feeding prisoners would have been a very significant component of the monthly cost, the annual cost. And I was quite surprised because you have a figure of 24 million for food, which translates to a cost of about $16 per day per prisoner, or just under $500 a month. However, looking at the staffing costs for the prisons, on average, it costs about $15,000 a month per prisoner. Now, I've already said, of that $15,000 a month, food is about $500. But basic salaries make up about $8,000 per prisoner per month. And if you add overtime and allowances, you get close to 10 or 11,000. So the bulk of the 15,000 a month per prisoner is in staffing costs. Now, if we reduce the number in the prison, we would reduce the cost of food, but we would still remain with the prison officers' establishment and the staffing costs as it is. So the question I want to direct to both of you is whether, in fact, cost of running the prisons is a factor in non-custodial sentencing.
Thank you, and through you, Madam Chair, I want to tell you right off, yes, it is a factor. In fact, when we computed the figures and we realized that to maintain one prisoner in the service, in the prison service, is over $15,000 per month, we recognize the need for reduction in costs. In fact, we've already begun to discuss ways and means of reducing that cost and looking at ways we could save on the expenditure that we are currently making on maintaining persons in prison. So that is a discussion that we've already begun. Let me also say, before I hand over to Commissioner Wilson, that I need also to add to the discussion here the fact that the Ministry of National Security has actually already begun the establishment of the electronic monitoring system in Trinidad and Tobago. This is where we're hoping to institute the whole business of non-custodial sentencing through offenders wearing a certain device and who could be released but be tracked and so on through this electronic system. In fact,
sorry to interrupt you, Mr. Burnham, Secretary, but before it flies out of my head, I need to ask, has the ministry acquired those devices?
The ministry has just awarded a contract actually to a firm to acquire the devices.
And how many are we looking at?
I'm sorry, I don't have the figures right now, but we are beginning actually immediately with 300 devices. And that should be increased over time.
Well, that was the question I was going to ask in terms of what are some of the obstacles, remaining practical obstacles into implementing that electronic monitoring? Is that the entire system of electronic monitoring? What are some of the final obstacles, apart from just getting the devices, which we just heard? Are there any other practical hindrances to bringing that into play?
I don't think there are any major obstacles after we've gotten the devices. I think there are some minor things that we need to do with respect to the order and those things, with respect to the police processes and so on that have already been drafted. So I think once the devices have been acquired, there are just some minor legislative things to treat with in order to put that system in place. In fact, we've already set up the office and staffed the office with a manager and some initial staffing to have the system up and running as swiftly as soon as we have been able to acquire the devices.
If I may, I'm just a little confused by this, but perhaps the Acting Deputy Commissioner, Mr. Dulalchan, might be able to shed some light. Is it, since we only are going to have 300 devices, is it the intention of the TTPS that these devices will be used for the purposes of persons who are on bail, or is it that they will be used post-sentence? What is the proposal for that?
Ma'am, I am really not in a position to speak to that, but just to say that, as PS would have said, we are advanced in terms of preparation. We have already prepared our draft SOPs. We would have trained about 361 officers thus far, and those are officers of the middle management ranks. We're going to recommence that training in the month of February. We have already identified who would be the liaison officer to the manager of the electronic monitoring unit. And my information is that the regulations need to be signed off by Cabinet. I'm just reporting what was told to me. But we are in an advanced state, and we are preparing ourselves to welcome this initiative.
Thank you.
Thank you, Chair. The question I have is for both DPP and the police service. It's with regard to, notwithstanding there is no legislation regarding decriminalizing marijuana, small amounts of marijuana. What has been the position? Is there any changing position in advancing non-custodial sentences for persons who are very small, who are caught very small amounts of marijuana? Because we are seeing here on the list of presented us by Ministry of National Security of 1,064 persons serving sentences of 5 years and less, 90 are incarcerated for possession of marijuana. Not sure if that is small or large quantities. So the question is, is there any shifting focus regarding non-custodial sentencing for persons who are caught with small amounts of marijuana?
From the policing standpoint, we don't have a position on this. We have to just abide by the law as it stands.
Can the DPP offer any?
I understand that this topic is particularly topical, and there are initiatives to engage the public by way of public consultation on this whole issue of decriminalization of marijuana. But as it stands, the Director of Public Prosecutions Office is guided by our standard tests as to where we go by way of prosecution of matters of this nature. And of course, that's a two-stage test. The first stage deals with the sufficiency of evidence, and the second stage is whether or not a prosecution is in the public interest. From time to time, the DPP's office may make interventions, especially where the offender is young, like a school child, so as to prevent the harsher realities of sentencing being visited upon those individuals, where they may have been charged with possession of marijuana or narcotics.
PS and Commissioner, just back to the cost issue, and the chairman introduced the electronic monitoring discussion. PS, you talked about reduction in the cost. We've established that the cost per month per prisoner is over 15,000, and we've established that a significant part, maybe as much as 10,000, is related to staff costs. And I, based on your data, calculated the food is about $500. So I'm trying to establish where are you targeting for the cost reduction for prisoners? And I want to specifically understand if there are plans to reduce the staffing costs. That's the first question. And the second question is, have we established, we know, we've agreed that cost per prisoner per month is 15,000. Have we established the cost per month per person of the electronic monitoring system?
Thank you again, Member, through you, Chairman. With respect to the first part of the question, and the reduction, the cost savings that we're proposing to make with respect to the expenditure on the prison service, one of the areas we're looking at certainly is in the overtime payments. After we've broken out the figures, after we've broken down the figures, we felt that that is at least one of the areas that we feel strongly we could restructure and to make some savings. There might be others that we haven't really delved into those very deeply just yet, but certainly that's one of the areas that we're looking at immediately. And the Commissioner could talk a little bit more about how we propose to restructure the, how we could allocate the prison officers' duty and time, shifts and so on to be able to achieve some savings in the overtime bill. The electronic monitoring, unfortunately, I didn't work with those figures, those details, but we have some estimates with respect to costs that I could perhaps share with the committee, maybe in writing at a later stage.
Okay, thank you.
Honorable DPP, you just used the word sufficiency of evidence. I know we want to eliminate PI, preliminary inquiries. What does the ordinary reasonable man glean the meaning of sufficiency of evidence?
It would be difficult for me to be so bold as to posit the reasonable man's interpretation of the term sufficiency of evidence. But as far as the law is concerned, evidence is considered to be sufficient if that evidence is such that to go forward with a prosecution on the basis of that evidence, there is a reasonable prospect of conviction. If the evidence meets that threshold, it's considered sufficient.
So in a case, no, if I could just go off just one point, Chairperson, with masters. With respect to masters now dealing with sufficiency hearings, and we don't have the evidence, what we call evidence, true evidence, or the Evidence Act coming into play when masters determine sufficiency hearing. Is that the same threshold? Is it a higher burden to overcome or greater burden?
The interpretation of the term sufficiency of evidence from the point of view of a prosecutor going forward with a charge might be different from the situation where a master is considering sufficiency of evidence. Similarly, in the case of a preliminary inquiry, magistrates commit persons at preliminary inquiries on the basis that the state would have made out a prima facie case. A prima facie case, to my mind, suggests a lower standard than the standard the prosecutor employs in deciding if to go forward with a prosecution.
Thank you, Director. I know that some of these terms are technical legal terms, but thank you for your very precise explanation. I have a question for the Chief Probation Officer. There has been some comment or observations in the courtrooms, family court, criminal courts, and so on, about the quality of the reports being produced by probation officers. Some of the comments have been that the reports are not quite up to standard, and the other comment is that they are so widely varying in standard that what I would like to find out is whether there is an education process, or do probation officers have enough time to have further education on the preparation of these reports, which play a very important part in the courtroom process.
Madam Chairperson, I am aware that the standard has dropped, and it has dropped incrementally for a little while now. What I have done is to, apart from the training that they get, because we have a hierarchical system where the PO3s are responsible for vetting the reports of the entire area. We are divided into geographical areas. We have the 2s vetting the 1s, the 3s vetting the 2s, and in very critical matters, the assistant chief or the chief myself, I might be able to make sure that the reports that go to court are acceptable. However, we have a lot of it's a first degree to get into probation services, and we believe that at least there must be a degree of, people should be able to have a proper English at least. However, we have several challenges with that, and I know sometimes it's like pulling teeth, trying to sanitize these reports before they actually go to court. Because of the number of matters we have, and we have to work so quickly, sometimes a number of them will probably fall through the cracks. What I have been doing right now is dealing with service commissions to get a written component, at least in the shortlist, to be part of the shortlisting, to ensure that the officers that come in this new batch will be able to produce at least proper English. So the content we will learn. Pardon me?
Thank you.
Okay.
No, I was just indicating to the member that he would be able to ask his question next, but certainly complete your answer.
Okay, all right. So as it is right now, we are working on the new ones that are coming in, and we do continuous training. Another one of the comments that I would have gotten from a judge recently is that some of the reports are vacuous. Now, we have the LSCMI risk assessment tool, which is supposed to be implemented before the report actually goes to court to determine the level of risk. And apparently that was not happening. I recently got wind of this, and we have put things in place to ensure that the information that reaches the court is what is supposed to be there. So we are working on it. It is a work in progress.
Thank you.
Yes, Martin. Maybe Mr. Karaspi could help shed some light on how effective and how successful has been the time off for good behavior. We see in one of the submissions here that it does exist, and it's up to the superintendent of prisons and so on to let somebody out on good behavior. How has been the experience with that program?
Through you, Madam Chair, the prison rules allow that facility for inmates who show good conduct and industry above the normative level to be considered for discretionary special remission. 3 days and 5 days. Those only apply, of course, to convicted persons. So when the inmate comes through the first 3 stages, having regard to the length of their sentence, they will then come into this special category. And if they are at that category prior to release, then they are entitled to make the request of the superintendent for that 3 days consideration. And if they have spent 6 months or more in that category, then they are entitled to make the application for the 7 days. So time is important for an individual, and to leave 3 days or 7 days is much better than leaving at the actual date where the normative remission standard will apply. The inmates who use it are inmates who are assessed after they have made the application, and if the superintendent is satisfied that looking at the length and breadth of the person's stay in the institution that they so qualify, then the superintendent will exercise that discretion and allow the special remission. So it is a facility that is used fairly regularly for those persons who have long stay, because in order to get to that special category, your sentence must be an average at 4 to 5 years in the very least.
Do you monitor what happens when someone has successfully utilized this facility in terms of follow-up?
I should perhaps make the distinction between the special remission that you're speaking to and the normative remission. Under Prison Rule 285, every offender who spends under 12 months is entitled to 6 months of half of the sentence, and the offender who is over a year, a third of the sentence. So those are the normative remissions that apply to every offender who is convicted by the courts. Separate and apart from that, then we come into the special remission, which is what I spoke to in your earlier question. So all offenders who are convicted, who fall in a sentence of under 1 year, are entitled to remission of half of, and over 1 year, a third of. That is the rules, and it applies, and of course this applies to good conduct and industry. When the offender comes into the institution, initial interview is conducted, and the offender is told what are the expectations, and if they conduct themselves and they show good industry, then they would be entitled to this part of their sentence.
Thank you, Chair. My last question today, and it has to do with victim satisfaction and a cultural shift, public education. In light of the submissions of the TTPS and the DPP in particular, as well as the illustration of the Commissioner of Prisons, what can we do as a country, or from your respective institutions, what do you think should be done, or as well as what we should do as a country to ensure this cultural shift occurs regarding plea bargaining and regarding acceptance by the population of non-custodial sentencing, by and large, and probably, I guess, in some specific circumstances where you would need public acceptance of a non-custodial sentence for there to be social peace. And anyone can...
Okay, could I through the chair, let me suggest that one of the things that the prison service has begun doing is getting the message out there, because within recent times, we have started, my communications department, we have started a program called Conversations with the Commissioner. And I use that forum to get all the messages out there, and of course, for the public to interact with me. Apart from that, we are also featured on one of the programs during the week, and that sensitize the public to various issues. So at least the prison service is trying to get the message out there. You know, like years ago, we were a guarded secret, a well-kept secret, and I'm trying to change that. So we interface with the public more, And I think what we need to do is carry the information to them so that they would be able to be better informed in terms of these processes and where we intend to go. So I think interaction, communication with the public is key. Thanks.
Thank you. I think we are running out of time because this room is required for another purpose in a short period of time. So I just want to begin the wrap-up because we have received so much information from all of you that I have to begin by thanking you for your tremendous input. The sad thing is that we couldn't continue for the rest of the day because then we may have been able to actually resolve some of the issues which have been raised here. However, what we will do is we intend to write you with questions which have not been able to have been asked during the course of this session, or questions which have arisen from what you have given to us today. And we hope that we will be able to have your responses before we do our report. Before I invite persons to do their closing speeches, could I just make what is perhaps a personal plea? Could we not refer to the housing of prisoners who are human beings as warehousing? I think in the context of the history of this beloved country of ours, we need to remember that human beings are human beings, and let us keep warehouses for property and for items and inanimate objects. But that is just my personal plea and an aside. I will now invite persons to make their closing remarks. And this time I will ask Acting Commissioner of Prisons, we will go from left to right, to make some closing remarks.
Madam Chair, I'd like to thank you and the other members of the committee for inviting the prison service here. And I sincerely hope that that word warehousing comes out of the, of the public domain, but I think it just highlights how persons feel about that whole incarceration process. But the prison service, I can assure you, is attempting to transition into something new. We have a lot of initiatives that we would be seeing from time to time, and I assure you that our main objective continues to be the safety of the public. Thank you very much.
Mr. Lewis.
Thank you, Madam Chairman. Again, I would want to thank yourself and the members of this committee for the opportunity to have presented here. What we've gleaned from the discussion here this morning, certainly useful to the work of the Ministry of National Security, specifically, of course, to the prison service and the probation services. And we go back to our offices with renewed vigor to support the work of this committee. Thank you.
Director.
Madam, thank you very much, Madam Chairperson, members. There was a particular point that we did not spend any time on today, perhaps because of the time constraints. But in examining the feasibility of widening the availability of non-custodial penalties in the criminal justice system, I think we need to be cognizant of the distinction between, say, serious criminal offenses and trivial or more petty offenses. If you look at our submissions closely, and I expect that you did, you would realize that in the magistrates' courts, for instance, which really is the mantelpiece of justice for most persons in the country, you would find that there are over 100,000 matters pending before the magistrates' courts. And of these, a significant amount speak to traffic offenses or regulatory offenses. In my respectful view, it is much more feasible to deal with these offenses in the context of widening the plateau as far as non-custodial penalties go. So I think we need to make that distinction because Non-custodial penalties in the criminal justice system may be wholly inappropriate where the offenses are serious criminal offenses. I would also like to add that these discussions, I dare say, and I fully understand the notion and the concept of separation of powers, but I would be so bold to say, I take the liberty to say that perhaps these discussions could be even richer if we were to have a representative from the judiciary, since a lot of the discussion on sentencing involves a critical stakeholder, which is the judicial officer, and the judicial officer's exercise of a judicial discretion, the moorings of that discretion, and how they are amplified. That type of discussion, I respectfully submit, may also enrich these discussions, and they may go a long way in the edification of the public. Finally, I would like to thank this committee for inviting my office to make a contribution here today. And I also want to thank all the presenters and all in attendance, since for my own part, and I speak on behalf of my colleagues, we too would have been the beneficiaries of this rather productive experience. Thank you very much.
And before I call on Acting Deputy Commissioner Dulal Chan, Director, perhaps I could indicate that we have written to the Chief Magistrate, and we hope to have some input from the Magistracy with respect to sentencing. Mr. Dulal Chan.
Madam Chair, on behalf of the Trinidad and Tobago Police Service, we also appreciate the opportunity to be here this morning and to join with the conversation. I also understand and appreciate this initiative, if I should term it like this. But just to say that we sit in here and we going to deliberate upon a person who is already a person who has been convicted. But I'm just asking whether or not also consideration can be given for that person who may probably have run afoul of the law, maybe for some trivial offense, and cannot meet bail, and that person is now remanded with the presumption of innocence until proven guilty. What also is his or her situation in the realm of what we are in fact discussing? Whilst we may want to contemplate that, I want to give the commitment that we as the TTPS stand ready to continue to support this committee in whatever way forward in relation to this matter at hand.
Thank you all very much. I want to thank the media, persons in the public gallery for attending, and the viewing and listening audience. There being no other business, this meeting is now adjourned. Thank you again.